Hello everyone, my name is Akanksha and under the internship of ubAdvocate under AOR Jivan Prakash, I've been assigned this task number 28 to record a video and present it based on a legal issue. So the legal issue that I chose was the constitutionality of section 377 of IPC 1860. So, to love and to be loved should be an individual right. But Section 377 of the British Colonial Penal Code criminalized all sexual acts which were against the order of nature, right? The law was used to prosecute homosexual people engaging in oral and anal sex. Although Section 377 did not explicitly include the word homosexual, it has been used to prosecute homosexual activities since the very beginning, right? Now, we will talk about the timeline of the events that actually determine the constitutionality of Section 377 over the period of time. Firstly, Section 377 was introduced in 1861 by British India. It was modelled on the Bagri Act of 1533. In 2001, Naz Foundation filed a petition challenging the constitutionality of Section 377 in the Delhi High Court. They filed a lawsuit to allow homosexual relations between consenting adults. Now, the Delhi High Court dismissed the Naz Foundation petition, saying the body had no standing in the matter. The Naz Foundation appealed this dismissal to the Supreme Court, and as a result, Supreme Court instructed Delhi High Court to reconsider this particular case, and Delhi High Court, in the further judgment, decriminalized homosexuality. Then, in December 2012, a two-judge bench comprising Justice G.S. Singhvi and Justice S.J. Mukhopadhyay of the Supreme Court overturned the decision that was taken by the High Court of Delhi, and this was termed as the Nalsa judgment. In 2018, Supreme Court, in the case of Navtej Singh Johar versus Union of India, or the famous case of Navtej Johar, decriminalized the homosexuality in India. We need to understand that the entire section of 377 of IPC is not decriminalized, but only the part has been decriminalized which concerns itself with the sex between two consenting adults, as the bestiality, which is still considered as a form of sexual activity against the order of nature. So bestiality still exists under section 377. So section 377 of IPC does not itself entirely stand as ineffective in today's arena, in today's world, in India, right? But the part dealing with the sexual activities between two consenting adults has been decriminalized, as it has been made very clear by the 5 judges bench of Supreme Court in the 2018 judgment of Navtej Singh Johar case, that if two consenting adults engage into any form of sexual activity, no matter what their sexual orientation is, no matter what their assigned gender is, it is not to be treated or termed as a crime. Now, just for concluding this part of the video, I would like to make it very clear that homosexuality is not a disease as such, as noted and held by the Supreme Court itself, but homophobia is. So to cure homophobia, we need to firstly acknowledge the fact that homosexuals do exist, and being a homosexual is not a practically and naturally impossible phenomenon, right? India still has a very long way to go in order to make Indian society inclusive and safe for the queer community, since homophobia still exists, right? And the internalization of the same has become a very big hindrance in the process of curing it. So we still have a long way to go, but this judgment definitely is a breakthrough in dealing with the homophobia that still persists in India. Thank you so much for watching this video.